Well, the short answer, and I always try to first give the short answer. Just because the debt's in your name doesn't mean there won't be a division of that debt. The key is not in whose name the debt is, but when the debt was incurred. And why is that the key? Because we're distinguishing between marital debt incurred during the marriage and separate debt. Separate debt that might have been incurred before the marriage. Now, if you've got debt that has come up because you took out a Home Depot credit card in your name and now you owe $12,000 on it because you went and you redid your kitchen. It's in your name. Your wife's never set foot in the Home Depot, but now there's a divorce. Is she going to be responsible for half that? Of course she is. She's going to be responsible for it. Why? Because it was incurred during the marriage. It was for the marriage. It was presumably for the marital home. It was for the benefit of everybody. Guess what? Half that debt is yours. Half that debt is hers. What if it's not for the marital home? But what if it's putting new tires on your spouse's car? You know what? That was also incurred during the marriage. That is also a debt that's going to be split. The court is going to allocate the debt based on joint debt, marital debt, and separate debt, which might be non-marital. Having said that, I want to give you one caveat. If the debt is in your name alone, but it's a marital debt, the court will say, okay, it's $10,000. $5,000 you owe, $5,000 you owe. But the bank is not a party to your divorce, which means the bank might only go after the one whose name is on the card, the one whose name is on the contract. And that might be you, which is why it's impossible, which is why it's very appropriate, and which is why it's mandatory that when you get that debt considered in your divorce, you get a split, because you're going to pay your $5,000 of it. You got to get the $5,000 that she owes too. Why? Because Home Depot's coming after you for the whole 10. They don't know about her. It could be the other way around too. If the debt is in both names and the court says, okay, the debt may be in both names, but the court is finding that only the wife owes the money, you know what? The bank's not a party to that. The bank can still go after both, even though the court made a finding that within the marriage, this debt belongs to one person. So you've always got to watch out for and determine what's marital and what's not. There are limited examples where the court might find that even if the debt was incurred during the marriage, it's still separate debt and not joint. I'll give you an example. Husband's having an extramarital affair and runs up the credit card debt buying gifts for his girlfriend. You know what? The court is not going to make the wife pay for half those gifts. That ain't going to happen. The court's going to make a determination and an appropriate allocation of the debt based on where it went and what it is. You have to remember, though, that it's in a rare circumstance. In most cases, the court's going to say, okay, it's marital debt. It's going to be divided 50-50. And maybe you don't like that. And maybe you don't feel that you should have to pay your share of debt that's in someone else's name. But remember one thing, you're going to need to protect your credit. You're going to need to make sure that that debt is paid back. So maybe you don't agree, and maybe you don't feel that it's right for you to have to pay for a credit card that's in your husband's name. But you know what? Since the bank's not a party to it, you've got to make sure that that bill is paid. That bill is paid to protect your credit. How it's paid and what the allocation is, that's for the divorce judge, and that the judge will determine exactly what the allocation of debt is.
248-588-3333. 248